So hello again, good morning. I didn't greet anyone, so my name is Carla Amado Gomes. I'm a professor of environmental law at this university, and I'm very glad to be here chairing this table. These are very unknown issues to me, so I'm trying to learn something with this day. On this second panel, we'll talk about corporate climate litigation. And we will have online Ivano Alona from the British Institute of International and Comparative Law. And after him, Miko Rajavori from the University of Turku. Ivano, are you with us?
Yes, good afternoon.
Yes.
Thank
Hello.
you.
I'll give you the floor in a minute because I have to present you first. I just wanted to know if you were here. So Ivano is, as I said, from the British Institute of International and Comparative Law, has a PhD in Comparative and International Environmental Law from the Sorbonne Law School, University of Paris 1, Panthéon-Sorbonne. He's a research leader in environmental and climate change law at the British Institute of International Comparative Law. He's a leader of the Climate Change Law Program and BILCL's Innovative Global Perspectives on Corporate Climate Legal Tactics project, which will hopefully create a comparative toolbox for corporate climate litigation. Ivano, we are very pleased to have you with us, and whenever you want, please.
Thank you very much for this introduction. So I'm going to share my screen. Let me see if it's working. Okay, you should see that.
Yes.
So first of all, thank you very much for the invitation to Eloisa. Thank you very much also to the other organizers. I think this corporate environmental responsibility workshop is really timely, and in a way, it's really also great to see all the different aspects that you treated already. You are going to see also later on. I'm just really sorry that I couldn't be part of this great event in person because, as you know, I'm already in Dubai for COP28. So I just have to accept to participate online, but hopefully we will have other occasions to be together in the same room and to discuss this a little bit more in person. So anyway, as Madam Chair said, we are going to discuss a little bit this global perspective on corporate climate legal tactics, which is basically the title of a project that we are currently developing at BICL. So before giving you an idea of what we are trying to achieve with this new kind of research, and these are in the last part, the new prospects that in a way it might entail. I mean, we hope that this is going to create an impact. I will just touch on some terminological precisions related to the field explored by this panel inquiry that we are going, that I have the honor to start. So corporate climate litigation, we are going to see some elements on its scientific basis, then its increase as a global phenomenon. And then I will have just a few minutes to mention a few relevant examples. So let me start with the terminology. This is actually something that now I think it's quite important because question of terminology. Just last week I was at this conference in France, and a great professor of private law immediately when I was speaking in French saying climate litigation against corporations, because in French it's more difficult to do this corporate climate litigation. So he said, I don't really agree with this kind of definition that you're using. I say, actually, the real one is corporate climate litigation, but it's difficult to translate in France, is more involving. So we know that private companies are a critical part of climate change, of this super weak problem. We know that time is running out. We know there is no central authority to tackle it. And also all those that are seeking to end the problem are also the ones that are causing it. But I really believe that companies might also provide the means to mitigate this problem, especially, as you can see on the slide, in the context of the current much needed ecological energy and just transition. So we have different aspects that I think companies can be part of the solution, not just part of the problem, as we are going to see in a moment. So in a way, when we're talking about corporate climate litigation, these allow us to see the contraposition between NGOs, citizens, local communities. Now we saw with California also governments, and on the other side, we have private companies. And this, in a way, is important to redefine, to use this kind of terminology. I think it's pretty much accurate, the one that you use for this panel, because we really should consider the companies, the private company, as the fundamental actors that they are in this fight against climate change. And so we should say that we are talking about litigation involving companies, because, you know, sometimes it's even more effective, the fact that the litigation is there, and even though it didn't succeed. Anyway, unfortunately, as you can imagine, it's not the only reason, because I'm proposing also, and I'm really happy that you chose this kind of choice of terminology. In this moment, as you probably know, we are currently witnessing cases where companies are invoking the courts to contrast the claimants with the famous SLAP lawsuits, like in Italy, where recently we have Eni, that you probably already heard about, this fossil fuel giant, which apart is owned by the Italian government, has filed these strategic lawsuits against public participation, so this SLAP, against Greenpeace and Recommon. Of course, one of the main cause of action is defamation, so they are alleging damages for defamation. The idea is to counter their joint legal campaigns of Recommon and Greenpeace Italy. And these lawsuits are utilized as corporate legal tactics, in a way, to suppress criticism by hindering public protest, and also, quite important, especially when you're talking with the NGOs, draining economic resources from the defendants. So in a way, it's quite it's quite important also to see that corporate climate litigation has two aspects. It's not just the company as defendant, there is also this other aspect, and this is something that we are really witnessing, not just in Italy. We had a similar case also brought by Total against Greenpeace in France and many others, so I'm not going to continue on that. So the scientific basis, in reality, I think it's quite important when we talk about corporate climate litigation to show a little bit the complex picture of this litigation that involves private company. And in particular, when we're talking about that, of course, we are always talking about the carbon majors. At least most of our attention goes there, because this kind of case is a little bit more sexy, as probably Kim Bauer would say. And so we are talking about these major greenhouse gas emitters. Mainly they are fossil fuel, cement companies. In 2014, carbon majors were already been identified by Richard Eady and the Climate Accountability Institute through an assessment of the historical contribution of these companies to greenhouse gas emission. That was a very important report. There was a peer-reviewed paper that circulated a little bit everywhere. Basically, this group of scientists that were led by Rick attributed 63% of the carbon dioxide and methane emitted between the half of the 18th century to the beginning of the 21st century to basically 90 entities, 90 private companies. So in a way, Climate Accountability Institute did a great job bringing together this kind of data. And so climate scientists now can run simply a climate model to calculate the amount of global average surface temperature and the sea level rise also, so all the effect of climate change that are linked directly to the emission from a carbon producer. And we will talk about this when we see one of the cases that I wanted to tell you about. So in a way, we have this new field of science that is going rapidly. We are talking a lot about the attribution science side, that in a way is tracked by also many other group of scientists around the world that are directly involved in climate litigation. We are going to organize next week at COP a side event with the Union of Concerned Scientists. That is another very important group of scientists working on the side, more on the side of the claimants than on the side of the private company, let's say. So just to go back to Ricchidi, so this famous geographer now is, he last year with another Italian scientist published new research that quantify and highlights that the worst of fossil fuel companies at this point. This is the second link that you see, time to pay the piper. Basically, the top fossil fuel companies owe at least $209 billion in annual climate reparation to compensate community most damaged by their activity. So if you consider what we are discussing at this point, the COP, with the Loss and Damage Fund, with the Green Climate Fund, I mean, we realize that this is an important amount. So, as I said, scientific evidence is growing. We have much more precision by the attribution science. I just mentioned the last point on this. This is an exciting book written by Naomi Reskes, who is also working in our group as Ricchidi, as part of our core group, and Eric Conway. They wrote this great book that is called Merchants of Doubt, which in a way shows the similarity between this new kind of litigation and before the tobacco industry's disinformation campaign and the effort to create confusion. So they were really creating doubt in the scientific knowledge, just to manufacture uncertainty, to stall the governmental action. And so, in a way, they tried to keep doing this kind of things also for the climate area. Increasing number of corporate climate litigation cases. This is something that we are witnessing. We are not just talking about the carbon majors. We are also talking many other kind of fossil fuel firm. So it's not just the holy grail, as our colleague Kim Bauer was saying, of climate litigation cases. There are many other polluting activities, industries that are involved. And so these are challenging corporate inaction on the climate crisis, the attempt to spread misinformation. And in a way, the companies start to recognize this as a risk. And of course, this is something that our friends from Sabin Center are keeping track of. And so now we have, this was a couple of weeks ago, but I think it's still this number. We have 212 cases in the global climate change litigation databases. And so considering that, I think in the database of all climate litigation cases, we have more than 2,400, we realize that we are still like at the inception of this kind of litigation. And we find here a lot of very interesting first cases brought against corporation. We had some cases coming from the 2012, like the very famous Village of Chivalina versus ExxonMobil. We have the American Electric Power also versus Connecticut, and we have also California versus GM. These are all initial cases brought in the US, where we had 3/4 of the cases around the world that failed under the political question doctrine or were preempted by federal statutes such as the Clean Air Act. So in a way, in the last decade, we really see the targets for climate litigation extended beyond carbon-intensive industries, in addition to this continuing trend in cases concerning a company's attribution to climate change through their greenhouse gas emission. We have many other kind of cases against business that goes around various sectors that start to emerge. So we are talking about, of course, I put in the slide, the director duties, the company obligation to adequately disclose the financial risk of exposure to climate change brought about by their business activity, but also this evolving landscape of climate litigation against government, that is the other side of climate litigation, is triggering further legal and policy change, which in consequence have ripple effect across the private sector. So we always have to keep track, to keep looking what happened also in litigation against the government. And so in a way, there is an extension, always more of cases, always more causes of action, different causes of action, legal strategies. That's why we were talking about this and we're working on this at Beaker. And so we have really many kind of high emitting sectors that continue to be the most exposed to transition risk. And we have just, we have sectors that are very heterogeneous. We have energy and natural resources. We have everything that is related to infrastructure, to construction. As you can imagine, we have this kind of risk in the transition. And we have, of course, the carbon intensive utilities that we already said before, but many others that are coming at this moment. And we understand that we should be able to prevent this kind of risk. And we have to discuss with them, because companies need to disinvest also capital, and there will be a lot of things going on from the point of view of the lenders, investors, and from the point of view of the reputational damage, as we will see also in the case that we are going to see. So, yeah, this is, as Mark Carney said, this is start to become really a financial risk. We are talking about stranded asset when we are still want to produce as in the past. So we just finish with some global perspective. In a way, I will just going to touch on three very important cases. There are three examples of corporate climate litigation. Interestingly, we have really something that is one for each country, very important countries, but also we have example. The first is brought by an NGO, even though there were a lot of citizens too. The second by an individual at the basis, even though there will be, as you see, also NGOs behind. And the third by a state, so the most recent one. So the first one, probably, if you are in this room, virtual room or in person, you already heard about this, is the famous Milio Difensi case against Royal Dutch Shell. As you know, Royal Dutch Shell is, at this point, Europe's largest oil and gas business by revenue. And this was sued a few years ago by this environmental group, Friends of the Earth, Netherlands, so Milio Difensi, and other NGOs, and more than 17,000 Dutch citizens. And they were alleging Shell's contribution to climate change violates its duty of care under Dutch law. So this is quite important because there is an interesting provision in the Dutch Civil Code, but they also interpret this provision at the light of the human rights obligation of business enterprises. So in a way, it's quite interesting because this kind of decision, they used a little bit the reasoning that was used in the Urgenda case against the Dutch government. But so we are still at the, we just had the first decision. So the Hague District Court ordered Shell to slash emission by 45% by 2030. And we are talking about the 2019 level, but we are talking about emission coming across all its operation and emission from the use of the oil it produces. So scope 1, 2, and 3. That's one of the great achievement of this decision. And of course, last year, Shell appealed the decision, so now it's still pending. And the court, on the other side, which is quite important, declare the orders to be provisionally enforceable. So we're going to see about this, but this has been the first very interesting case, but was the first successful one. The second one is slightly different because we are not talking anymore about mitigation. We are talking more about adaptation. And it is a case that has been brought by the Peruvian farmer Saul Luciano Luya in 2014, so it's already 9 years, against the big energy company that is RWE for its contribution to climate change. So we have very different kind of aspect compared to media defense. We have this transnational character because the claimant, which, as I said, has been also supported by an NGO, by German Watch, argued that climate change is causing the glacier near his farm in Huaraz in Peru to melt, which result in flooding of his community. And so according to Luciano Luia, RWE's contribution to climate change and the related flood risk amounts to unlawful interference with this property. So we are talking about something that is a private law, basically. There is an article, a provision of the German Civil Code. This is the paragraph 1004 of the BGB, of the German Civil Code, which tells about this. So in a way, this is quite interesting because Luciano Luia asked the court to order RWE to pay for their share of the adaptation cost to help protect his community from flood. And what they use there to calculate this, but they use the same carbon major research that I was mentioning before, this Climate Accountability Institute rekeyed this research, and basically they trace back to RWE the precise amount of 0.47% of the overall CO2 emissions in the atmosphere during the industrial era. So you realize they could really calculate how much money they owe RWE to Luciano Luia. Is not much. It's not much, we have to say. It's a strategic litigation, as some colleague would define it. We are talking about $20,000, so it's not really much. As this financial contribution for building defenses, so it's really the adaptation part. But on the other side, if this kind of case goes well, then really can open great perspectives. So we're going to see, we are waiting. There is, the judges went to Peru last year, the German judges from the High Court in Hamm went last year in Peru. So we are still waiting to see what is going to happen. There is another very interesting case that is a little bit similar with some islander from Parry Island in the Pacific, against Holcim company in Switzerland. And also this is about adaptation, but also compensation is also quite interesting case. We finish with the one on California. As I said, very interesting also this case because it's brought by state, in this case, one of the most, the richest state in the US and the most advanced from the point of view of environmental law. And last September, so a couple of months ago, the California Attorney General filed an action in the California Superior Court against 13 fossil fuel companies. There is ExxonMobil, but there is all the very known one, and of course the American Petroleum Institute, alleging that the defendants were substantially responsible for causing accelerating climate change. And this is quite interesting and relates to what I said, that book of Naomi Oreskes. They had knowingly concealed and misrepresented their products' dangers, causing a delayed societal response to global warming. I'm quoting this text from the plaintiffs. So the complaint asserted statutory clauses of action for public nuisance. There is much more, is equitable relief for pollution, impairment, and destruction of natural resources, untrue or misleading advertising, and we're always going in the side of greenwashing, which is becoming always more important, and unlawful, unfair, or fraudulent business practice. So in a way, this is really asserting something like strict liability, but also strict product liability, negligent product liability claims. There is a lot of this. There is some very, let's say, old causes of action, some new ones, and in a way, I think this is quite important because they are also seeking to award the cost to the state. So this might be really a case that create ripple effect around the world. And we finish with the global toolbox, as we call it. This project that I said is called Global Perspective on Corporate Climate Legal Tactics. We are striving in the last year and a half to work with 17 countries to produce this global toolbox on corporate climate litigation. So basically, we are mapping and analyzing in a comparative way all the different causes of action, all the different arguments, procedure, evidence, and also, of course, the remedies that have been used. We are analyzing also all the problems that we find in this kind of litigation around the world and the different legal systems. And it's interesting because in a way we realize that even though the community is really strong already on climate litigation, we really need to learn from other fields. So, as I said before, tobacco, of course, but also asbestos, toxic torts, but even other fields that are not completely related to climate change can give some ideas on the tools. That's why we are talking about a toolbox to engage, as I say, in more strategic, prospective, and interdisciplinary thinking. We have Rikidi, we have Naomi Reske, we have Brian Preston, Michael Gerard. We have a core group with people that are judiciary. They are from academia, they are practitioners, great practitioners, the scientists. I think this kind of discussion is the thing that can help us create a more comprehensive and effective climate action, climate litigation, and also, as I said before, even if it doesn't succeed, it's really important because it raises public awareness, eventually encourage, this is what we hope, corporate actors to mitigate the litigation risk by changing business behavior. So this is what we are trying to do at this point. We are going to present this in London in March, and we are going to also to create at the same time to present also a database that we are working on at this point, which will be based on our work on the toolbox and will be in connection, of course, with Sabine and Grantham. Anyway, I stop here. I hope that I didn't took too much of your time, and I thank you for your attention, and I hope then afterward, if there are any questions, I will be really happy to respond.
Thank you, Ivano. Very creative box of tools you are working on. Let's see what comes up. After your presentation, we will have the pleasure to hear Mikko Rajavori. Is he with us? He is. Hello. I would like to just say that Mikko, he has a PhD in law and he's an assistant professor of law at the Faculty of Law at the University of Turku. He is advisor to companies, NGOs, and the government on issues as varied as corporate governance, foreign investment, and business and human rights. Mikko, it's a pleasure to have you here. The floor is yours.
Thank you. Thank you. Pleasure to be here virtually today. I shall share my screen. Can you see it? Okay. Excellent. And you can hear me, I guess.
As well.
Yes. And now I will try to put this video thing somewhere where it doesn't block my view. Okay. So name is Mikko Rajavori. As said, I work as an assistant professor at University of Turku in Finland. It's currently minus 15 degrees here outside. It's probably a bit different from Dubai, but it's all good. I like to call myself an economic law scholar, and I focus mostly on companies. And as a part of this focus, I also do sustainability, whether it's like new regulation or contract or corporate or tort law. And my topic today is at the intersection of these different streams, and it's about the interactions between so-called due diligence laws and corporate climate litigation. Now, this talk is based on a recent paper, which I co-authored with Annalisa Savaresi and Harald van Hasselt, who I think many here know. And in a nutshell, our argument is that the interplay between due diligence laws and litigation, it outlines this sort of a distinctive vector of corporate climate accountability, but the scope of that accountability may be quite limited. And to get there, I will briefly first introduce what due diligence laws and climate litigation are all about, and then talk about the interactions. So due diligence laws, as we know, these have emerged as a major part of the contemporary corporate sustainability regulation. And due diligence is obviously a term that many different types of lawyers, from international law to transactions, use. But the due diligence we're talking about today refers to management of a company's social or environmental externalities. And this notion was created in the mid-2000s, early 2010s in international soft law, principally the UN Guiding Principles on Business and Human Rights. And it essentially put forward an expectation for companies to assess their human rights risks and do something about them. And due diligence has become a very popular notion, and it quickly emerged as sort of a go-to quasi-legal concept around which companies' social and environmental responsibilities were measured against. And since then, a whole international soft law framework and industry has been built around the due diligence. Over the past 7 to 8 years, I'd say, due diligence has also grown beyond soft law, and it's increasingly legislated on both domestically and regionally. And on the right, I have a piece of German Supply Chain Due Diligence Act that was passed a few years ago. And this and similar domestic due diligence laws have essentially transplanted that original soft law conception into hard law obligations, but with varying components and intensity. So here we have a selection of jurisdictions that have passed or are passing due diligence laws. We can see that it's mostly European affairs so far. Curiously, there seems to be nothing coming out of Portugal, but probably, or perhaps you have something in the works that the persons that put this fine map together did not see. But the point is that this picture sort of includes all types of due diligence laws, but those laws may be very different from one another. And the key observation for us today is that due diligence laws have so far rarely mentioned climate change in any substantial way. There are exceptions for sure, but the bulk of due diligence laws is still embedded in human rights issues. Now, on the contrary, climate litigation, as Ivano was talking about, it has taken a keen interest on various climate impacts, and litigation has sort of emerged as a very important legal response to climate change over the past decade or so. And litigation, it's not against companies only, it's against like a broad swathe of actors like states, cities, individuals, companies as well. And the basis for this litigation, it's also very varied. So we can use constitutional law, we can use environmental law, we can use human rights law, we can use tort law, etc., etc. And here on this screen, I just have like simple graphs that show the trend line. So increasing litigation, but also the geographic spread of litigation, which shows that Europe is still the hotspot for climate litigation. And as Ivano was covering in greater detail, a key subset of climate litigation is corporate climate litigation or climate litigation against companies. And with climate litigation in general, corporate climate litigation, it builds on like varied legal bases such as financial disclosures or consumer protection or tort litigation or environmental permitting, etc., etc. And as a whole, this corporate climate litigation is very rich and complex phenomenon, but from our perspective today, it's enough to say that there is going to be more of it, and that corporate climate litigation will have an effect on climate change policy and company operations, but we do not yet know how big that effect is going to be. So we have more due diligence laws, and we have more climate litigation, and both of these governance streams, if you can call them that, they are interested in corporate climate accountability. But do these different phenomena or bodies of law, do they intersect, and in which ways? This was basically the question and the premise of our paper. And at the time of research and writing, there was very little scholarship out there on the climate dimensions of due diligence laws in general and their implications with climate litigation in particular. The work of Chiara Macchi, who spoke in the previous session, that there was an obvious exception. But this is why we wanted to look into the dynamics of due diligence laws and corporate litigation and see how they interact, if they interact. And in our view, they do interact. And we have identified a few ways for them doing so. And I have the scenarios here, and I'll expand on them shortly. But our general argument is that there are 4 types of interactions. So first, due diligence law legislation or due diligence laws, they can provide grounds for climate change litigation, as has already been done very explicitly in France. The second scenario is that climate change litigation can fill gaps in the scope and reach of due diligence laws, as happened in the Shell case Ivano was talking about in the Netherlands. The third scenario is litigation as a driver for new due diligence laws, perhaps due to industry pressure, because litigation can severely impair a legal certainty that companies quite like. And finally, due diligence laws can also impede climate litigation. So here I have the picture of the EU's corporate sustainability due diligence proposal. But the idea is that there are design choices in due diligence laws which may actively reduce litigation opportunities. So these are the 4 different ways that we found due diligence laws and climate litigation to interact and shape one another. There may be other interaction types, but these cover many instances in how litigation and legislation can mesh, in practice or on a broader social level. And what I'm going to do now is to go through these interactions in a bit more detail. Our first scenario is that due diligence laws could be used as a grounds for climate litigation, meaning that legislation would enable a greater set of claims to be made. And in France, there are already several cases lodged under the domestic due diligence law, but that kind of direct claims are very rare. And there are many reasons for this, but the main ones are likely that due diligence laws are very new and very few of them are currently in force, and also that they do not necessarily contain a mechanism for lodging direct claims by private parties, for example. And more will likely come in the future, after the adoption of the EU's due diligence directive in particular. But this is the situation right now. The few direct cases that we have, they are also characterized by severe challenges to the validity of the claims. So again, in France, these cases have been through a grinder just to find the correct forum. And that's before actually engaging with the substantive parts of the claims. And there, the climate dimensions may actually prove quite tricky. On the other hand, due diligence laws, they may have indirect effects on climate litigation. Because the due diligence laws, they usually require companies to produce and communicate extensive amounts of information on their supply chains, etc., etc. And this information has in the past been used as evidence to construe claims against companies. So in the 2019 case from the UK Supreme Court, Lungove versus Vedanta, there, for instance, company's own reporting and communication data was a big part of the plaintiff's winning argument. And with the advent of the due diligence laws, there may be more opportunities, more information available for plaintiffs to construe their claims creatively. The second scenario we had was gap filling, and this means that courts may extend the reach of due diligence obligations even if there is no legislation or that it does not contain environmental issues in its scope. We remember that due diligence concepts, they arose from international soft law, and they initially focused very heavily on human rights and other types of social risks. And in these conditions, litigation, I think, actually provides an avenue for reconceptualizing the reach of due diligence obligation to also include climate change. And the best example of this is the Shell case, where the Dutch court, they brought in an extensive reading of a corporate due diligence obligation and alignment with international instruments like the Paris Agreement, and they interpreted existing domestic tort law provisions from their perspective. So in essence, the Dutch court willed a due diligence obligation pertaining to climate change into existence without explicit statutory support. In some places, courts can do this. In other places, courts cannot do this. So it's very jurisdiction dependent. But the point here is that it was climate litigation and corporate climate litigation that prompted this type of judicial exercise and interpretation of due diligence duties. There are not many other domestic examples of similar dynamics, but we can see a rather similar process happening, for example, in the OECD system, where national contact points have occasionally pushed the notions of corporate climate accountability when dealing with violations of the OECD guidelines. And this process has also led to changes to the soft law instrument itself. So the OECD guidelines on multinational enterprises, the responsible conduct of multinational enterprises, which were amended past summer. So this was the second scenario. The third scenario we identified is litigation as a driver for legislation. And this, I feel, is quite clear. Corporate climate litigation, it makes the stakes and injustices embedded in our legal system very acute, and they are they are quite easy to translate, for example, to civil society action. So because we have these glaring accountability gaps, we also need regulation to close those gaps. But in addition, and perhaps more importantly than civil society action, companies themselves may be triggered by climate litigation to demand regulators to step in. And the premise here is that litigation and transnational tort litigation in particular, it's quite random. And having some kind of a domestic or international standard to follow would actually benefit companies going forward. And we have seen this play out many times, but of course, companies, they are also quite smart in lobbying regulatory strategies that favor their position. And finally, it's also possible that courts themselves, they compel authorities to issue new regulations or even laws. And this is an edge case for sure, but we can refer to the example from the US, where the US Supreme Court held that Environmental Protection Agency was required by law to regulate any air pollutant which could endanger public health or welfare. So the court told the legislator, or in this case, an administrative agency, to make up new regulations. I don't know if this could play out in the due diligence law context. I'm not so sure, but the broad dynamic is like applicable to our context as well. The final scenario is that we can also understand due diligence laws to hamper or impede climate litigation. And the most obvious scenario here is that future due diligence legislation, it will be conservative, and it will include different types of safe havens that reduce the efficacy of the due diligence law. So perhaps climate obligations projects are isolated from a general due diligence obligation, or perhaps there are new defenses that companies can use to escape litigation. And another question is how the penalties and remedies are organized. So if a due diligence law relies on administrative oversight and penalties, can we actually see a risk that the general tort law system gets crowded out, that there is no point in lodging private law litigation, and instead we have to rely on government doing its part? Does it do its part? I don't know, but the way that the penalties and oversight are organized in these laws, it's quite important in my view. And the point, more general point, is that more laws does not necessarily mean more litigation. It can go the other way also. So, in sum, what we did in the paper was to identify 4 different scenarios through which due diligence laws and climate litigation interact. And I have some lessons that we can draw from this analysis here on the slide. So first, it's obvious that there are links between the two, and climate change litigation will definitely affect how due diligence laws operate. And I like to think that litigation, it crystallizes due diligence obligations and makes climate change sort of legible from their perspective, even if it's if the climate change or environmental issues are not included in the scope of the due diligence law. This has not always been the case, and it may still be that the kind of a conceptual origins of due diligence in human rights may clash with the environmental and climate side of things, even though we have seen convergence over the past few years. Another finding is that due diligence laws, they won't be a fix-all solution, and that their effect for climate litigation is likely to be indirect rather than direct. And this is again, in my view, largely due to the legal design of due diligence laws. And in particular, we can see that clear lean towards administrative oversight and sanctions. And while this kind of administrative system has potential for litigation, authorities can initiate proceedings, or perhaps civil society can act on behalf of the victims in third countries or what have you. But in general, having this kind of a dynamic plaintiff-centered civil law system, it could be more dynamic than an administrative system. And we'll have to see how the European due diligence directive will be designed and implemented in member states. But my hunch is that what we will see is more regulatory state and less plaintiff-centered litigation, and that may or may not be a good thing. I don't know. Perhaps Ivano has a point on this. So one final thought is that because due diligence laws are at the moment a very Western phenomenon, I think we need to be quite sensitive to the effect of these laws for the whole litigation ecosystem. And I think that we as Europeans especially, since we are passing these laws en masse, we should be quite critical towards the system level ramifications of due diligence, and also think it through from this kind of a holistic corporate climate litigation perspective. So does due diligence crowd out corporate climate litigation opportunities from the global south? I think that's a valid concern. I don't know how it would actually play out, especially since or after the introduction of and passing of the EU's sustainability directive. But these were more or less the issues I wanted to discuss today. I have few papers out with colleagues that deal with these and other issues that are sort of relate to the same overarching theme. They are you can find them on the slide right now, and I'll be happy to send them your way if you're interested. But other than that, I will say thank you, and again ask or thank the organizers for having me here today.
Thank you, Mikko, for your presentation. I will now pass the word to Matteo Vermeglia for comments. He has a PhD in law from the University of Udine and Trieste. He's an assistant professor of climate change law and governance at the University of Amsterdam, Faculty of Humanities and Amsterdam School for Regional, Transnational and European Students. It's a pleasure to have you back in Lisbon, Matteo. So we are looking forward to your comments.
Thanks, Carla. It's always a pleasure to be back in Lisbon, which is, despite being relatively freezing, as we discussed, definitely milder than Amsterdam nowadays. And it's obviously a pleasure to discuss this issue. And I want to thank sincerely Ivano from COP28 and Mikko from definitely Freezy, Finland, for their comments on this issue. And I have noted some points, of course, in relation to both presentations, actually, which I think tap into the broader point that I would like to make. Embracing this kind of role as a discussant, which is we're supposed to discuss possibly in an adversarial way the topics that are being put on the table. And while I was thinking about what to say in terms of engaging with this role, I have been increasingly bending towards a very critical standpoint. And in fact, my general point that I want to throw in this room today is challenging the real ontology of what Ivano and Mikko mentioned as corporate climate litigation or litigation against companies. Meaning, is there any reason or any purpose to challenge companies on climate change issues? And this is a very bold statement, of course. There are, I think, reasons to do that, and I think both Ivano and Mikko have explained why we should do that. I would also like to point out, however, that there are counter arguments to that. And of course, I want you to follow me on this one. So there are, of course, trying to recap, at least 2 or 3 major upsides of challenging corporations from a strategic point of view, right? We have the issue of putting pressure on companies' actions, accountability, increasing ambition. Actually, of course, private actors are those who are fueling climate change. Let's be honest about that. They are not states, they are not public authorities, they are not international authorities. The entities that are driving climate change, are driving global warming, are mostly private actors. So we have all the numbers out there to testify that. There is the second point, of course, related to framing litigation as a financial risk for corporation. And there is a very interesting study out there by Joanna Setzer and others, really putting some numbers out there. I'm just recapping here one number based on current litigation against corporations, which basically summarize the fact that against average economic benefit for a company around $197 million in terms of a positive outcome for the company, of course, in relation to a strategic corporate climate litigation. We have almost a double, $360 million in terms of negative economic impacts of a negative outcome of corporate litigation, such as the Shell case, for example. So these are very interesting studies that are increasingly framing the issue of corporate climate litigation as a financial risk for corporations. And then, of course, there is the broader societal awareness impact in terms of uprooting, even civil disobedience against a system which is well ingrained, that has been driving change, has been driving climate change for decades. So with this in mind, however, I want to point out that all these 3 elements, and especially the framing of corporate climate litigation as a financial risk, actually hits on a very crucial point, which came to my mind the more I was listening also to Mikko's presentation about due diligence, which is, and this is the provocation I want to throw in this room actually, which is indeed, after all, corporate climate litigation is not pointless, but is misled as it stands right now. Why is it misled? I think it is essentially misguided or misled due to the fact that it basically neglects the fact that the targets of this litigation, carbon measures, for example, HEDI studies, brilliant, do not operate in a political economic vacuum. I think corporate litigation is targeting, is aiming to put a sort of a red label or black label on certain companies, certain entities that have been definitely contributing to climate change. And this is again established and more increasingly fine-grained by climate science. But the underlying problem that I think corporate climate litigation is missing somehow, or we all have to realize, and I think we are in the privileged position to have this discussion, is that in fact, carbon intensive industries in particular, so I will just focus on carbon major, they are not the problem as such individually. The problem is the corporate structure that operates in a social economic system that we all need to fuel our society. This is the big problem that we have to face. Climate change is driven by what? Climate change is driven by the increased need for material and energy throughput, which is necessary for what? Basically, to fuel our capitalist growth-dependent society. This is the major elephant in the room, of course. Second, corporate behaviors, including carbon majors, is of course strongly influenced by the need, the imperative to A, maximize profits, B, maximize economic growth, and therefore fuel a system which, since the 80s, have been pivoted around the concept of sustainable development, which I strongly challenge, which I strongly doubt, and is still, as we also heard today, still underlying the main responses that we are trying to put forward, also in courtrooms, of course. And this is, again, don't take it as a sort of blanket from over corporate climate litigation. I do think litigation is important, but I think we have to really think about the sort of underlying concepts that are driving this process. So basically, my assumption is that while challenging, especially carbon measures, we are basically challenging a behavior that is nothing but business as usual. Basically, carbon-intensive corporations have been doing, they are currently doing exactly what they are supposed to do in the first place, which is accumulating capital and providing us with goods, services, oil, gas, you name it, that will ultimately fuel our economic well-being. And by our, I mostly refer to Western developed countries. And this is a very major, I would say, question mark or, let's say, caveat, of course. So with the understanding that, of course, the underlying system, which we are not necessarily challenging with corporate climate litigation, is basically growth dependent and is basically, again, dependent on energy throughput, essentially. And as we have shaped our society, basically this energy throughput has been, and unfortunately, I'm afraid will be for the next decades at least, fueled by essentially fossil fuels. COP28 is a great example of that. There is a this treadmill kind of situation that we are facing when we talk about corporate climate litigation. And again, the treadmill is basically where you have, well, pre-established roles by corporation that essentially fuel this kind of economic growth narrative that is ultimately difficult to challenge in court. You might wonder why still the Shell case is the unicorn of corporate climate litigation. There are several climate litigation that worked, were successful on a project-based ground, like opposing a coal pit or open pit coal mine, opposing an industrial facility for environmental, cultural, even greenhouse gases emission arguments. The greenhouse gases emission argument is always on the side, by the way, in those litigation. But I wonder why, indeed, the Shell case is the real unicorn or the holy grail, as also Kim Bauer mentioned, warning against relying on holy grails when addressing strategic climate litigation. And again, you might also tell me, well, we did the same with tobacco industry, right? Tobacco industry knew about the health impacts, mostly the health impacts of their products since forever. And we managed to put them on the stand and to put them paying for this. I'm saying, yes, but this is completely different. And this is what is problematic about corporate climate litigation with a specific focus on, of course, oil and gas industries or carbon majors. And I would also like to see how this will play out vis-a-vis other kind of industries, for example, the livestock, the agricultural industry as well, which is not too much focused on so far. The problem and the difference with carbon majors and with this kind of economic actors and what makes them historically unique is that those industries are, as in our current socio-economic system, which scholars, governments, states, international organizations have contributed to construct and to build up, are the one we need, are the precondition for the world in which we live today. And this is the sort of general provocation I want to put in this room. I would like to have your honest thoughts on that, because I see many young people here that could have probably more brilliant ideas than I do on this point. I don't want to put any I don't want to put so much depressive notes over there. But again, just as a last point, touching a bit upon what also Miko was saying, because I think it's pointed in terms of especially the due diligence discussion we had also this morning earlier, is really how the law is actually reinforcing this system. It's all nice to have obligations, due diligence, requirements about impacts over a supply chain. Very nice. It can be helpful in courts if you have very progressive courts, like the courts in The Hague, which can also rely on certain underlying conditions to come up with very progressive judgments, which, by the way, are shaky on many grounds. We can discuss about that. But at the same time, I wonder, what is the throughput of this outcome? For example, the EU Sustainable Due Diligence Law. And there's also for something that maybe Miko hinted at when he was talking about the whole machinery of EU law. Who is putting the inputs on this throughput? I'm just dropping the question over there, because if we take a truly critical stance on this, we will realize that even if this would be probably a good weapon to achieve what we want to achieve, namely reduction of greenhouse gases emissions, possibly reduction of pollution as well, and basically the Paris Agreement targets reached, well, we are using the same tools that are contributed to the problem. And plus, this is the last point I want to drop, most of these instruments, especially within the EU sphere, are instruments that are driven by certain economic, cultural, and social underpinnings that, as Miko mentioned as well, and I do agree with that, might not be suitable for those who are actually suffering this health, economic, and climate change impacts in the long run. Most of the companies that we are taking to the stand in Western jurisdictions are companies that are operating mostly in the global south, and they are mostly delivering the human rights impacts, environmental, and well, also climate change impacts in the global south. So I think also as scholars, we want to engage more. I think we need to engage more on a global, not global south perspective on these issues, because I'm personally quite troubled with having a Brussels effect going on with these issues, which to me looks as sort of neocolonialism. And with this, I'm dropping the pen. Thank you.
Thank you, Matteo. Blame Western society would in short correspond to your commentary, with which I very much agree with. So you have a vote here, but you don't need it anyway. So now something completely different.
God has spoken.
Yes, okay,
It's fine. Sure.
okay. Go ahead.
So, yeah, thank you. Do you have the right to reply, or we wait? No, thank you very much, Matteo. I pretty much agree with most of what you said. On the other side, of course, this is something that I've been thinking a lot about. I think that we are coming from very similar position. I completely agree that at the basis there is a problem that is related to the paradigm of the productivism, the capitalism, everything that created what we are today. But I don't agree on the fact. I don't agree on saying that today and what we are just relies on this and for the next years, because I think that now we have. First of all, I pretty much agree with what David Boyd said a few years ago, that we have an obligation of being really optimistic about the outcome of our fight against climate change as environmental lawyers, generally. On the other side, we know, everybody knows now, apparently, except for Al-Jabar and some of these people at COP. I hope I won't get killed. I'm joking. But yes, there is much of an alternative to fossil fuels. At this point, we know that it's like this. I mean, we were talking about this, about the wedges related to the different kind of renewables since the 90s. And we're still asking ourselves if we can live without fossil fuels. Of course we can. So corporate climate litigation for me is not the solution, is part of the many possible tools that we have in our climate governance to fight climate change. Is not the best option. The first option is to have great negotiations and to have these the different part, mitigation, adaptation, the aid to the poorest country, well established, working well. But on the other side, we know very well that last year Sharm, this year Dubai, and we see what they are saying right now. So we are dealing with a framework geopolitically, which is not easy. For me, corporate climate litigation could be one of the interesting answer to this, because in a way we are trying to foster the ambition of fossil fuel companies, not just the big carbon majors, but also all the others, and try to make sure that they are going to take a higher pathway. I think at this point, we have a problem with climate governance, which is a very common political science kind of mechanism, which is the regulatory capture. We think that what we are doing when we are talking about with our legislator, when we are bringing them in front before a court, is conclusive and is fine. But on the other side, we have to understand that we are not, our democracy works in a way that we are not the real boss in the story. The real boss are the fossil fuel companies that are bringing them to become president of the United States, for example. So in a way, regulatory capture, let's go directly where is the source of this kind of emission. As Matteo rightly said, we have probably 70% coming from these 100 entities. It's easier than goes one by one to 200 countries, mostly without great capacity, and the rest without a lot of freedom of movement in this kind of issues. So for me, this is my very short reply, because I think that Nico is going to reply everything else about the human rights due diligence. Thank you very much. Thank you very much, Matteo, for what you said. Thank you very much for all of you. And Nico, also, I really appreciate your paper that I read before, and also your explanation today. Thank you.
Thank you, Ivano.
Okay, so perhaps
Miko?
yeah, so perhaps yes, I can hop on, and of course Matteo's point about the systemic processes, driving climate change, and the responsibility of the or the role of capitalism in all of that. It's very true. It's like in Godfather 2, Michael, or was it Godfather 1? I don't remember anymore. But Michael Corleone talks to the state senator that we are all part of the same hypocrisy. And that's very true. I mean, if I look at my investment portfolio, or if we all look at our pension fund portfolios, we will see a Shell there. We will see all types of companies that me and Ivano have been looking at that are being the litigation is going towards them. So it's very hard to distance oneself completely from that the capitalist accumulation system, and having that kind of a critical reflection once in a while, it's a very good thing, and keeps you humble in a way. Perhaps I could step in and build on Ivano's point that the corporate climate litigation or litigation against companies, climate litigation against companies, it's one tool in the toolbox, and here I have always been very intrigued by private law dimensions of climate change law. I mean, we tend to think climate change in terms of public law, public international law, for example, what they're doing in the COP right now, or public law in general. So what kind of solutions states come up with, environmental regulation, the emission standards, and whatnot. And just as Matteo has like a controversial statement, my controversial statement is that perhaps we talk about corporate sustainability a lot, but perhaps environmental law has nothing to do with corporate sustainability. Perhaps environmental law is not that important. And what is really important is private law. It's how corporate law works, how contract law works, how tort law works, because it's essentially those private underpinnings that on top of which our whole world economy is built on. And this relates to climate litigation, especially if we look at, say, the Shell case. I mean, it's an exceptional case. The Dutch, they are doing Dutch things, and not many courts in the world do Dutch things. But in that case in particular, what is ingenious is the legal strategy that the plaintiffs chose. And it was not to demand reparations. It was not to claim damages. It was to place an injunction. Injunction based on Dutch civil code, or now I don't know the exact statute, but in any case, the point was to say to the company, please stop. You have an obligation to stop. We don't care what you have done in the past. We only care what you are doing in the future. And by bringing in that kind of a forward-looking, private law-driven perspective on climate litigation, I think that's actually revolutionary, and that's where the kind of a recalibration of tort law doctrines, of contract law doctrines, of corporate law doctrines can perhaps be sought and made operational. So, well, what I'm saying is that through these transnational tort law cases, for example, courts are being put in the place where they can do things with private law doctrine that legislators, that states, they cannot do, because there's no coordination in COPs, there's no coordination in national parliaments, and it's in private law sphere where I'm the most optimistic for the potential for corporate climate litigation, and also for like this kind of a long-term nudging of the legal system towards this kind of a sustainability mindset. It's not in the environmental law departments; it's in the private law departments. That's my concluding thought.
Thank you, Mikko. It's frightening, frightening scenario for us. Anyway, last words go to Eloisa Oliveira. She has a PhD in law, and she's a guest environmental law professor here at the University of Lisbon School of Law. She is also a researcher fellow at the Lisbon Public Law Research Center, and a consultant at the legal service of the Portuguese government, Jurizap. I wonder how she has the time to do this all. The floor is yours.
Okay, thank you very much. This wouldn't be an environmental law conference if degrowth and capitalism were not mentioned. Didn't you want to make some shameless propaganda about your book? You later on? Okay. So I'm essentially also going to talk about what I think is another underlying problem, not capitalism, but an underlying legal problem. I'm specifically going to talk about Miko's paper and how I think we might look into the impact of due diligence laws in corporate climate litigation. So my belief is that we are trying to transition from an area where we have very generic duties at best, so due diligence and duties of care, and trying to evolve into something that imposes more specific duties on companies. So I will not agree with Miko in what concerns environmental law not being relevant, of course, but because I'm an environmental legal scholar that believes in totalitarianism of environmental law, what I will say is corporate law will become environmental law. That's my point. But in any case, what I wanted to challenge here is the notion, let's get a critical perspective on, is it good to move from generic duty of care duties to specific due diligence duties? Like, for example, in the EU, what we are witnessing with the proposals and what will come, obviously something will come out of it. So what we're looking into in the future. So generic duties, of course, bring uncertainty, and this is a problem, mostly for the society, of course, as a whole, but mostly for companies, because companies, of course, don't want uncertainty. And of course, this creates economic impacts that no one really wants due to uncertainty, freeze on investments, and it creates litigation, of course, because it's not a specific duty, and therefore it gives more room for discretion, gives more room for conflicts, etc. This is all true. However, it is also true that climate litigation and corporate climate litigation or environmental litigation in general is also a way of ensuring that we identify specific duties, but concerning specific impacts. So when we look at a case and we are talking about due diligence or duty of care, it is true that we are talking about the generic duty, but we will be looking into the specific consequences that happened in a case and making a retrospective analysis and seeing, did this company do what it should have done to prevent this from happening, whatever it was. So it's a case that is always, of course, in court, it's very much retrospective when we are talking about corporate climate litigation. Whereas when we are considering specific duties, due diligence and reporting duties, information mechanisms, so all those aspects concerning corporate governance, we are actually mostly talking about defining these duties that are essentially procedural and formal, and not exactly making standards concerning results. So when we're talking about corporate due diligence in the law, we are never talking about the consequences of what the company has done in the sense that the consequences that we must measure and look at the results of what the company has done, but just looking at how much did it pay an effort. And this seems to me to be something that will actually not be good for climate protection and for environmental protection. In fact, I mean, we all know the song, so bees don't do it and birds don't do it, but states do it. States try to defend themselves constantly in court, saying, well, we have complied with all these duties, information duties, and we cooperated and we did procedures. Well, unless we have some true substantive goals and standards, if it's just due diligence, wouldn't it be better to let it off with an old instrument like a duty of care and due diligence that is generic and therefore can be adapted to each sector, instead of just trying to make up these very specific duties that I believe in a few years we will look back and see what did they actually produce other than reports. I mean, we reported on stuff, that's great. Of course, we'll also have greenwashing, tons and tons of greenwashing, but let's assume there won't be that much greenwashing, which of course it will, but let's assume not. So what? They reported on this, oh, we're going to make efforts to do. Well, if we don't at least, at the very least, have some self-regulatory commitments, so companies themselves having to ensure that they will get to certain goals, get to certain, for example, circularity rates, reduction on greenhouse gas emissions, use of papers, etc. I don't see how this is actually helpful, having more specific duties on due diligence than having a generic duty that forces companies to actually prevent something from happening. Because this is the whole idea of due diligence and duty of care, is you give it the attention in order to prevent a certain result. So it's very much focused on the result and not on the procedure. So I have to wrap this up because I don't have a lot of time, but I just wanted to challenge this notion that maybe this is a good path. I'm not sure that this is a very good, helpful path, because what we are in fact talking about is when environmental law first emerged, we started regulating, dangerous activities for the environment. And those are the activities that were covered by environmental law. But what we know now is that all companies, well, all of us individuals as well, but all companies have a high environmental cost, regardless of the activity. Of course, we can't say, oh, we're going to regulate all company activity according to, very strict environmental standards. But in fact, that's what we are, timidly trying to do. We are timidly trying to say, even if it's not an industry or whatever that has a very clear environmental impact, even if it's just a company in the financial sector, it still has an environmental impact and we still have to regulate it, do we? Is that how we should be doing it? Like we did for industries. We did not tell industries, oh, just tell us what you do. No, we say, you have to comply with this goal and this goal, you can't emit more than this and you can't emit that. Of course, it's easier because it's more specific activities, but I'm just saying maybe this procedural way is not a very good way to go. And also another thing that I wanted to add is very shortly, it's a very difficult topic. Well, not for me, but for most people, in the sense that I have made up my mind about this and I don't care what other people think. The environment is an object of legal protection. Like life is an object of legal protection. I don't have to make a law saying the specific duties that people have to comply with not to kill people. It's like, you should not kill people by throwing them under a bus, giving them poisoned food, thrust them through the window. You don't have to specify this. Why? Because life is an object of legal protection. So you have a duty not to create damage to that object of legal protection, life. Why is it not the same for the environment? Why do we need these specific? Because I'll tell you right now, companies, what they will do, and Miko has talked about this, what they will do is say, we complied with our duty of care because we did all of this reporting. So that is what is going to happen. So this would be my not so optimistic, perspective on this. So I will wrap this up. Thank you.
I just say a couple of words, but really very short, because I will need to Miko the pleasure of responding on that, because it was more his topic than mine today. So I would say that it's true that there is some problem with this kind of the use of this kind of tools, the use of human rights due diligence, for example. But on the other side, we have to consider that we are working now in a paradigm as lawyers that have been established in hundreds of years, not decades, hundreds of years. So from Roman law, and now we have to just adapt something that is a part of our tradition, legal tradition, of our mentality, our style, to the new challenges that are the complexity of climate change, the problem related to environmental law in general. So what I'm saying is, basically, we cannot give for granted that we will come up with some great ideas. And so I agree with Eloisa that there are some problems related with this kind of tools. But on the other side, if you see, is really a sort of, I think that Matteo thought about this, a sort of solidification, of densification. Also Mikko, at a certain moment, talk about this, of some other instruments. We were talking for years about corporate social responsibility. Today, if I say about something about that, people think that I'm swearing. But yeah, corporate social responsibility have evolved, densified, solidified, and so in a way became what is becoming human rights due diligence. And we have to understand that you cannot go in a path that is just evolution. Like, we didn't have a Paris Agreement that was top down. We understood the problem of Kyoto Protocol, and we tried to find a way of having a bottom-up, more transparent kind of instrument. So I think that what we are trying to do is to do what another Italian tried to explain us years ago. I don't know if you ever read this book from Ugo Mattei and Fritjof Capra, Ecology of Law. This is really what is going to put together all the different ideas from Mikko to Eloisa. We are privatizing environmental law. Is no doubt about that. I was talking with Gilles Martin, the person that was saying, no, don't talk about corporate litigation against corporations. But we are privatizing environmental law, is undeniable. Environmental law is really important, probably not authoritarian, but we are going since 40 years in that direction with the law and economics, with economic instrument, with everything. So there is an evolution. And I stop here and I leave Mikko to respond about the rest. Thank you very much anyway, Eloisa. I really appreciate your comments.
Thank you, Ivano. Mikko.
Yeah, Eloisa, that was, I agree with both commentators, apparently. I think your analysis of due diligence litigation, this kind of a move from general to specific, every time we make that move, we risk that the end result will be tick a box compliance, quite big Excel sheets with different colors, and that's it. Also the point that it's about procedure and not the results. That's very clearly ingrained in the DNA of due diligence laws, and I think that's also the reason why we have so many. They are so harmless for states and for companies, at least have so far been. Also, if we look at the design of those laws, we very quickly see how they take this from general duties to specific duties. They take it to the extreme. So if we take a look at, for example, the German Supply Chain Due Diligence Act or the EU's Corporate Sustainability Due Diligence Directive, and we take a look at the annexes, and we take a look at, okay, what kind of rights are included, or what kind of environmental calamities are included, what kind of treaties, what kind of rights. We see a long list, but it's not that long of a list. And how those very particular treaties, how those very particular rights get included in the law, that's anyone's guess. But what happens to those rights and those environmental problems that do not fit into these existing boxes? When we create this kind of very elaborate legal certainty for companies, okay, you have to take a look at these treaties. We also very likely say that, okay, but they are not that important, and that's always the risk when we are going from general to specific. Okay, so Ivano mentioned law and economics, and I think there's one final thought that we could bring on the table, which actually connects to the private law litigation and my last comment. If you remember, the one of the fathers of law and economics is Richard Posner from the US, and if I remember correctly, it was in 70s or 80s when he was very much criticizing the rise of the regulatory state and rise of these administrative agencies like the Environmental Protection Agency, which now proliferate in international and national environmental law. And what Posner's take was that we really don't want this. Instead, we want flexible tort law provisions, and we want the people that are affected to actually, themselves protect their rights. We want mass litigation. We want to make it easier for people to pool their resources and go against the big companies and go against the state. And we want to do it with flexible dispute provisions and not with these kind of specific instruments and not with that much of administrative oversight. Now, obviously, Posner, his version of this debate, it's very extreme. I'm not sure if that's a very good way to go about it, but it sort of ties into this idea of, so what is general, what is specific, and also what kind of a societal actor is actually responsible for enforcing these new obligations when it comes to corporate sustainability. I don't know the answer, but there may be something there in Posner's ideas, and I'll leave it with that.
Thank you, Mikko. We had a very intense debate here.
Okay, thank you. So we will resume this at 2:30 p.m. Portuguese time for financial law and sustainable finance. So everything it's leading up to those two panels, and corporate governance and corporate reporting. So I have tried to trash it. Now you try and defend it. And I'll see you later. Have a good lunch.
Bye-bye. Thank you.
Thank you.